Hi, I'm Amy Privet, the attorney for Privet Legacy Planning, and we are continuing our series that I call the 5 P's of Revocable Living Trusts. And this series is all about the benefits that a revocable living trust has to offer estate planning clients above and beyond what they might get with a standard last will and testament. This is the 4th video in the series. We've already talked about privacy, we've talked about probate avoidance, and we've talked about prevention as the first 3 P's. And today's P, the 4th P in the series, is protection. And I'm really thinking of protection in 3 situations. The first of which I kind of already alluded to in the first video in this series talking about privacy, and explained that a trust allows you to keep your private information private so that the world doesn't know your business and the world doesn't know the level of assets that you may be leaving to your heirs, to the beneficiaries of the trust, to your children. And in this protection arena, I'm really thinking of people, we'll call them predators, who may come after your children and try to insert themselves and wiggle their way into your child's life because they are aware of the size of the inheritance that your child has just received. They may want to be their new best friend. They may pursue some sort of romantic relationship with your child, all because they want to help them spend their newfound wealth and benefit from the financial blessing that you may have left to your heirs or to your children. Again, this idea of privacy and how you can protect your children is explored more in that first video, so I would encourage you to check that out. But protection from trust is also important in a second arena, and that's the creditor situation. I have my bucket of trust assets here, my Hershey Kisses, and when I'm thinking in the creditor realm, if I am your heir and I actually inherit money directly from you and I'm holding that inheritance in my hand, these assets are now subject to my creditors. It may be the bankruptcy court. It may be the credit card company who's sending me collections notice. It may be the utility company because I wasn't able to pay my water bill. It could be that I've been sued and I lost that lawsuit and now there's some sort of legal judgment against me. If I hold my inheritance in my hand, it is subject to my creditors, whomever they may be. But if those Hershey Kisses, if those assets are remaining in the trust, and I, as the trust beneficiary, have limited access to my inheritance in the trust, then I will get protection from my creditors. To give you just sort of a sneak preview idea of generally how this works is we would create a limited access window to the trust to say from this point to this point, this is when the beneficiary would have a right to withdraw assets from their trust. But at some point that window closes and that beneficiary can no longer have access to the assets in the trust for a period of time. And by closing that window and not allowing them to get to the trust assets, those assets will be shielded from any of that trust beneficiary's creditors. The third arena where protection comes up in the trust planning world is sometimes it's necessary to protect the trust beneficiary from themselves. This often comes up in situations where we have an heir that may have an alcohol dependency or drug dependency issue. And the concern is if they get an influx of cash or assets from the trust, then that money may be used to actually cause harm to themselves. In addition to drug or alcohol dependency issues, sometimes we need to protect the heir because they are in a destructive relationship. It may be an abusive relationship, It may also be a relationship that has turned sour and a divorce is on the horizon. And again, the concern is that if the trust beneficiary got all of the money out of the trust outright, that it may end up being split with their soon-to-be ex-husband or soon-to-be ex-wife through some sort of divorce scenario. Protecting the heir from themselves could also be a very simple issue that the heir is just not old enough. They're not financially sophisticated enough to receive the size of inheritance that you may have to offer them. They may be a minor, they may still be in college, or they just haven't had enough real-world life experience. They don't have the maturity level to be able to handle the inheritance. And so for a period of time, certainly not for always, but for a period of time, we need to protect them from themselves when they might waste the money instead of making wiser, more mature decisions about what to do with their inheritance. So again, the 3 areas of protection are to protect your heirs from predators, to protect them from creditors, and to protect them from themselves.